Good afternoon, everyone. And for those joining from the US, good morning. Welcome to the next in our summer IP webinar series entitled IP, Licensing and Insolvency, an International Perspective. I am Adrian Tatunji, a transactional IP partner at Taylor Wessing based in our Cambridge office in the UK. And joining me today are three colleagues, Dr. Dirk Wiedekind, who's an IP and media partner in Taylor Wessing based in our Hamburg office, Marie Kieup, who is a counsel at Taylor Wessing based in our office in Brussels, and Jamie Klesturis, who is a transactional IP partner at Wilson Sonsini Goodrich and Rosati, based in Washington, DC. So today we're going to be talking about the impact on a party to an IP license of the insolvency of the counterparty to that IP license. And this is a very topical issue. The impact of the COVID-19 pandemic has pushed many companies into a distressed situation, and many of you may already be giving some thought to how to deal with a licensed counterparty who's showing warning signs of financial distress. And we're going to do this by way of a case study, which I'll introduce shortly. One of us will then lead off with some comments on how the case study would play out in his or her own jurisdiction, and then the others will comment on any differences if the case study were taking place in their jurisdiction. And we'll look in turn at, first of all, an insolvent licensor, solvent licensee, and we're assuming a domestic license situation, so both parties in the same jurisdiction for simplicity. Then we'll make a couple of tweaks to the facts of the case study to make it a cross-border license situation. We don't have time for an exhaustive analysis of what will actually be, in reality, quite a complex situation where you'd almost certainly need IP counsel and bankruptcy counsel working together, but we'll touch on a couple of complexities which can arise in that type of cross-border situation. And then we'll finish off by looking back at the domestic licensing scenario, but this time standing it on its head. So we're looking at a solvent licensor and an insolvent licensee. And all three, just to repeat, will be based on the same case study. We'll also touch on some practical tips which you can take both in advance and upon notice of an insolvency to protect yourself from an insolvent counterparty. Now, joining us today, we've got delegates from a wide range of industry sectors, ranging from, on the one hand, from life science and wireless communications, where patents and know-how licensing are probably most commonly found, through brand-rich sectors, where trademark licensing will be of most interest, to content producers and media organizations, where I guess copyright licensing, publishing agreements are likely to be of most interest. And so just to flag that the same principles that we're discussing today apply to all types of IP, with only a few exceptions, which we will try and call out specifically. The case study has been designed to try and wrap in some branding aspects and some patent aspects, but we couldn't think of a case study that was simple enough in the time available that could have covered all possible bases in terms of IP rights and issues which might crop up. We do want the session to be interactive. There is a Q&A bar at the bottom of the window, so please do use that to raise any questions you've got. We'll try and deal with the most commonly asked questions during the webinar, and any others we will follow up with after the webinar. There'll be a survey at the end of the session too, so we'd be very grateful for your feedback. And just to reassure you that you are not on video or audio, both have been muted centrally. And finally, I should add, as you'd expect in the usual way, that we can't deal with any questions specific to just one company. The contents of this webinar do not amount to legal advice. So moving on then to our case study this afternoon. So here we are looking at, and I'll just take you through the facts of the case study. We have a situation of a company called Mobilitex, a well-known mobile phone, handset, and network infrastructure manufacturer based in country X in the late 90s and 2000s. By 2010, falling margins caused it to shift away from mobile phone handset production and to focus on its network infrastructure business. So in 2010, it sold what remained of its mobile handset business to a company called Ultrasoft, another technology company also based in country X. Mobilitex retained its IP portfolio, but granted Ultrasoft, that should read, granted Ultrasoft an exclusive worldwide license, trademark license, to market handsets and accessories under the Mobilitex trademark. And so we have this company, Ultrasoft, which continues to market its own Mobilitex branded mobile phone handsets under the trademark license. And it has actually entered into a royalty-bearing sub-license, again under the mark, with a company called GlamTouch, to market handset covers or cases. So that's the branding aspect of the case study. Following the sale, Mobilitex focused on its core business of developing, manufacturing, and selling network infrastructure. Following a messy patent infringement dispute with a company called Connetics, they entered into a non-exclusive, royalty-free worldwide patent portfolio cross-license. So that is the scenario. And the issue that we're faced with is that Mobilitex, the licensor, has been hit badly by COVID-19. Its lenders have refused to extend any further finance, and it's entered into an insolvency process. The insolvency practitioner doesn't believe it can sell the business as a going concern, but it would like to sell the valuable IP portfolio, in particular the trademarks and patents, to third-party buyers. And obviously the insolvency practitioner is thinking if it can sell without the licenses encumbering the underlying IP, then the value of that IP may increase. In relation to the patent portfolio license, it's thinking, I don't need the benefit of a cross-license any longer. So can I renegotiate? If I have to retain a license, can I renegotiate and turn this into at least a royalty-bearing license? So just let me switch back to a diagram which summarizes this for you. So you can see on the left, Connetics, that's the licensee under the patent license. Mobilitex is the licensor, which is in blue because it's insolvent. And then it's granted a trademark license to Ultrasoft, and Ultrasoft in turn has granted a trademark sublicense to Glam Touch. So that is our scenario. And with that, I will pass over to Jamie, who is going to take us through the key points about how the US would approach this scenario. Jamie, over to you.
Good morning, everyone, or afternoon. Pleasure to be participating in this webinar. So I think the core question here is whether the license rights of Mobilitex's licensees and sub-licensees would survive a Mobilitex bankruptcy, were this a US bankruptcy, and its sale of its patents and trademarks to third-party buyers out of that bankruptcy. Or alternatively, would those third-party buyers acquire the Mobilitex patents and trademarks free and clear of the licenses that were previously granted to Connetics in the case of the patent, and Ultrasoft and Glam Touch by way of sublicense in the case of the trademarks? So the first thing to recognize is if we were in a US bankruptcy proceeding, is that for any contracts that impose burdens on Mobilitex, and that is to say contracts which under which Mobilitex has some ongoing performance obligation, or in the US nomenclature, executory contracts, the bankruptcy will give Mobilitex or the bankruptcy trustee some special rights that it wouldn't have were Mobilitex not in bankruptcy. The patent cross license with Connetics and the trademark license would likely be considered executory contracts. There might be some analysis that would have to go into that, but I think for purposes of our discussion here, we can assume that those would be executory contracts in a US bankruptcy proceeding. And so in that case, Mobilitex or the bankruptcy trustee can choose to either assume the license agreement it has with Connetics for the patent and Ultrasoft for the trademark, meaning keep those agreements and perform the agreement and accept return performance from the licensees. Or alternatively, it can choose to reject those licenses, in which case Mobilitex would not retain the agreement and would no longer be burdened by them, with the slight twist in the bankruptcy that the rejection of the contract would be treated as a breach, but it would be treated as a breach not on the date of the rejection, but on the day before the filing of the bankruptcy case. So we would expect Connetics and Ultrasoft and Glam Touch to be highly interested in having their license rights survive. And the issue for those licensees would be case two, the rejection. In that case, Mobilitex would be out from under the license agreement, no longer burdened by them. And Mobilitex will be deemed to have breached the day before bankruptcy filing, leaving those direct licensees, Connetics and Ultrasoft, claim for damages. And because the breach will be deemed to have occurred the day before bankruptcy, those will be unsecured creditor claims, along with potentially many others. And we would assume that the damages for that would end up not being worth much, pennies on the dollar, when considered all the other creditor claims. So, the question is that it? Are these licensees totally out of luck? And will the third-party acquirer acquire the patents and trademarks free and clear? And the answer to U.S. bankruptcy principles if this was a U.S. bankruptcy case is, fortunately for the licensees and unfortunately for Mobile Text, where it's third-party buyer, under a U.S. bankruptcy in the rejection scenario, relieving the debtor licensor, that's Mobilitex, of its obligations under a rejected license isn't necessarily the same as taking away the license right of a non-debtor licensee. And focusing on just the patent cross license for a minute here, Section 365N is a specific section of the U.S. Bankruptcy Code that allows a non-debtor licensee, here Kinetic, in the rejection scenario to either treat the license agreement as permanent or retain rights under the Mobilitex patent, so long as, one, it timely makes an election with the court, so paying attention to notices from the court and acting on those notices with bankruptcy counsel is important, and two, continues to pay any royalties provided under the agreement. So we're dealing with a cross license here. Normally those might not have royalty payments associated with them, though one party has more patents than the other. There might be some form of balancing payment involving royalties. So Kinetics would have to continue to pay. And then the third wrinkle, which shouldn't apply significantly, is more a software issue. Kinetics, as a licensee, won't get anything new under that license. We'll just get the rights it had the day before the bankruptcy. So that's often an issue in software licenses where you're depending on a bankrupt licensor or maintenance and support and the like. Not such a big issue here. So that's great for Kinetics. The issue is, the next question is, what about Ultrasoft and Glam Touch with respect to the trademarks? And one issue there, a significant issue, is that 365N doesn't apply to trademarks. And so for this reason, historically under U.S. bankruptcy law analysis, a distressed trademark licensor would face a significant risk of losing trademark rights in the event of a U.S. bankruptcy. But there's a very recent decision from last year in a case called Mission Products that went all the way to the U.S. Supreme Court, where the court ruled that because a rejection of a contract constitutes a breach, the result of a rejection in bankruptcy would be the same as the result of a breach outside of a bankruptcy. And so therefore the debtor here, Mobilitex, can stop performing its affirmative obligation under the agreement, but it cannot rescind the license already conveyed. And so Ultrasoft, as long as, if you looked at the agreement and a breach by Mobilitex did not result in a termination of the license, which presumably it wouldn't, Ultrasoft should now be able to continue to practice under that trademark license. Mission Products is a very new development in the law. It leaves open some questions. When does retention of rights by one party actually translate into burdens on the licensor that can be avoided by rejection? So here it may be the case that Ultrasoft could lose its exclusivity. That might be viewed as a burden on Mobilitex. That's an unanswered question coming out of Mission Products. It also doesn't get into questions about what a licensee or sub-licensee needs to do to preserve some rights. So the resolution for Glam Touch is less clear, but in the end, the question for Glam Touch may come down to what the head license between Mobilitex and Ultrasoft says with respect to something. With that, I'll turn it over to Adrian on UK approach.
Thanks, Jamie. So if we move on then from the US approach to the UK approach, and just focus very briefly on, are there any changes or differences between the UK approach and the US approach? First point to say is that, as in the US, entry into an insolvency process doesn't automatically affect rights under an IP license under English law. So there's no automatic termination. And similarly, unlike US law, you don't even have to choose whether you're going to assume as a trustee in bankruptcy a license agreement. You just step into the shoes of the company before it reached an insolvent situation, and you continue in those shoes. But there is a power under the Insolvency Act for a liquidator, not an administrator, to disclaim onerous property. And onerous property in English law means unprofitable contracts on the one hand, or property that's not readily saleable. There's very little guidance actually about what very little guidance. Sorry, we're having some technical problems here, but I hope everyone can now hear me. There are some difficulties. I think very little guidance in English law about what amounts to an unprofitable contract, particularly in the context of IP. But there's a significant likelihood that an IP license would amount to an unprofitable contract, in particular if there are obligations, for example, to renew, so to pay renewal fees for registered IP. So the liquidator or the licensor has the opportunity to disclaim that license agreement. One thing to note, though, is that similar to the position in the US, that doesn't affect the rights and obligations of the licensee, which continue. One other opportunity a licensor, an insolvent licensor's bankruptcy professional has, is to disclaim the underlying IP itself, which in effect is allowing it to lapse. The licensee would then be exposed to some competition. But in those circumstances, a licensee does have the right to apply to the court before the lapse to have that IPR, which has been disclaimed, vested in itself, so it can step into the shoes of the licensor. A couple of interesting points to flag about the rules of assigning IP subject to a license, and these are the same rules as apply outside an insolvency situation. And these rules are actually pretty poorly understood, both by insolvency practitioners and by parties. The assignee is bound by the license. That's not the same thing as saying it's bound by all the rights and obligations in the license agreement. It's simply the grant, the permission to do something that would otherwise be an infringement. The assignee of the underlying IP is bound by that, whether it's an exclusive license or a non-exclusive license, unless it's what we call a bona fide purchaser, so a good faith purchaser for value without notice of the license agreement. So having notice of the license agreement is really, really important. That is why on the next bullet, we've got the importance of recordal of the license at the IP registries covered by the territory of the license agreement is really important, because that will put any assignee of the underlying IP on notice of the license agreement. So there is a real risk that a licensee, so in this case, Ultrasoft or Kinetics, could lose their rights, whether an exclusive license or a non-exclusive license, to use the relevant IP, at least in the UK. There's an interesting question, which I won't go into now, about where the territory of the license is broader than just the domestic territory, just the UK in this case, then whose law applies in deciding whether the purchaser of the IP is bound by the license agreement or not. I'll just flag that as an open issue, and people can raise it in questions if they're interested. Final point to note in the UK is that the licensor's rights under the license agreement, so the benefit, which might, for example, be the right to receive royalties, if those are part of the deal done by the insolvency practitioner, then they have to be specifically assigned. They're not automatically included in an assignment of the underlying IP. It's a different asset class. And with that, I will pass over to, we're going to ask Dirk now, who's going to speak to us about differences between the US analysis and the German analysis.
Yes, thank you very much, Adrian, and hello everyone. Thanks for taking the time to join us for this webinar. So the German approach is not very different in its initial conception from what we've heard from the US and the UK, with one exception. There is no statutory rule that would govern the fate of intellectual property licenses in the Insolvency Act in Germany. So the general rules applicable to all contractual relationships would apply here. And these rules leave the fate of the license largely in the hands of the insolvency administrator. Just like in the US, for any contract that imposes ongoing obligations to perform on the insolvent entity, in this case, Mobilitex, the insolvency administrator has a right to choose either to continue the agreement or to abandon it. If he continues the agreement, then the insolvent party can continue to enjoy the benefits of the license, and it remains obligated to perform its obligations under the terms of the agreement. After the administrator has chosen to continue the agreement, those obligations will be preferential debts. So any debtor that continues that relationship after the insolvency administrator has approved the contract will have a much higher chance of actually being paid or receiving royalties in this case. Should the insolvency administrator decide to abandon the agreement, then the license ends, and the party will, of course, no longer be able to use the licensed assets if it's the licensor who chooses non-continuation of the agreement or receive any license payment. Again, just like in the other two jurisdictions that we have already addressed, the licensee that is faced with a non-continuation of the agreement has the right to assert claims for non-performance and breach of contract. But of course, the likelihood to actually materialize substantial claims here is low, because those claims will not be preferential debts, and they will only be realized at the insolvency quota, which is basically the percentage of the claims that could actually be paid. So ultimately, they are of very little value. So where does this leave the companies in our example? Now, there are a few exceptions to this general rule that apply here. And they don't have to do with the nature of the IP right, as we've just heard in the US, but more with the structure of the license. So first, sub-licenses are privileged. Now, that may sound strange first. Why should a sub-license be less susceptible to the insolvency of the main licensee? But in most of the IP codes that we have in Germany, the Patent Act, the Trademark Act, there are statutory rules that protect a licensee against an assignment or another change in the ownership of the original license. And on the basis of those rules, the courts find that if a licensee is protected against an assignment, they should also be protected against an insolvency, and therefore a sub-license will generally continue even if the principal licensor becomes insolvent and the administrator chooses not to continue the principal license to the licensor of the sub-licensee. Now, in this case, this means that the license granted to Ultrasoft would probably survive the insolvency of Mobilitex. There's a second exception, and that concerns exclusive licenses. German law, at least in the case of patents, has held that exclusive licenses amount to a right in rem, a property right, rather than just a contractual obligation. And such a property right would entitle the licensee to separate ownership of the license from the insolvent assets, and they would not fall into the insolvent estate and could therefore continue to be exercised. Now, to what extent this can be applied to trademarks is not ultimately settled. There's a lot of uncertainty here, but at least there is a good argument, in this case for Ultrasoft, that the fact that they've obtained an exclusive license would protect them against the insolvency of Mobilitex. And finally, a third exception that I haven't actually included in the slide here due to lack of space, where a contract that has mutual obligations has been fully performed and all obligations have been met, that will also not be affected by the insolvency. And that could be the case here because we have an exclusive license that has been granted royalty-free. So depending on the further details of the agreement, there is an argument for Ultrasoft that they have obtained something that actually amounts to a purchase of the right, if it can't be rescinded and if it doesn't have any ongoing obligations of Ultrasoft. And if that was the case, then the license would also be protected against the insolvency of Mobilitex. Right, so it's a bit of a mess in a sense because there are no clear and unequivocal answers, and many attempts have been made to codify new rules that would expressly address such situations, but all of those attempts have so far failed in the parliamentary process. But that may change in the future. But for the time being, that's where we stand. And with that, I would pass to Marie to discuss the situation under Belgian law.
Thank you, Dirk. And hello, everyone. So I'll talk about the situation in Belgium. Before I start, I'm just going to point out two things. The first one is that I will be talking about bankruptcy, because the rules in Belgium on the treatment of contracts in the context of bankruptcy and in the context of judicial reorganization, which is another insolvency proceeding, are different. And here in the case, we're talking about a business that cannot be sold as a going concern. So we will be in the event of a bankruptcy proceeding. Second point I wanted to raise is the fact that in Belgium, when we enter into bankruptcy proceedings, this leads to a divestment of the debtor. So this means that the bankruptcy administrator that will be appointed will have full control over the administration of the estate. So the debtor himself will not have any say on what is going to happen. So now to go back to the difference with the US in how IP license agreements will be treated. So first, as for Germany, we have no provisions in Belgium that are specific to license agreements. So these will be treated as any other agreement. And second, even though the principle is that of the continuation of ongoing contracts, there are situations where a contract can be terminated automatically on the opening of a bankruptcy. The first one is if the IP license has been entered in consideration of the person, what we call intuitu personae. And the second situation is if the IP license contains ipso facto termination clauses in the case of bankruptcy. So these termination clauses are enforceable against the bankruptcy administrator, which will have to comply with the terms of the contract. If the contract is not terminated automatically, the bankruptcy administrator still has the right to terminate an agreement, but only if it is in the interest of the estate. So here you will have to look into the contract and see if it is a burden to the estate, or on the contrary, if keeping the contract could benefit the estate. If the contract is terminated, it's the same as for UK and Germany. As I've heard, the contracted party will be entitled to a compensation, but this compensation will be subject to the rules around the allocation to creditors and will be an unsecured debt, so it will be likely be paid last. In our case, if we look at the contract, first about what we call the intuitu character, this is rarely the case in when we're considering a licensor, because a licensee is going to enter into a license agreement in consideration of the IP rights and not of the person of the licensor. So it is unlikely that the IP license will be terminated on this ground. Second, we would have to check the contract to see if there is any termination clause. But if there isn't any, it will be up to the administrator to choose. And here, as a trademark license is a royalty-free license, it does not create any revenue. So what the administrator will have to do is to assess whether there is costs that are likely to be incurred. So, for example, fees falling due, or if the existence of the license will likely decrease the value of the IP. So these are elements that could influence the decision of the administrator. The reasoning will apply exactly in the same way in relation to the patent license, so I won't repeat the reasoning. There is no specific provisions in this regard. So this is what I wanted to say about Belgium, and so I'm going to pass it on to Adrian, who will present the cross-border case.
Great.
No, sorry. First, we're going to go through key recommendations for licensee.
Thanks, Marie. Now, the IT gremlins are continuing at my end, so I actually can't advance the slide. So could I ask one of my colleagues to advance the slides to the key recommendation slide? And then we can run through these quickly. So if you're a licensee faced with an insolvent licensor, or a licensor that you are concerned is teetering on the edge of insolvency, here are some suggestions. First, make sure you register your license, at least in the key jurisdictions of the territory of the license agreement. Secondly, consider taking security over the underlying IP, particularly where there are obligations of the licensor to be secured in that way. And then obviously make sure you register that security again in accordance with national law. That is a counsel perfection. In many cases, that will be difficult to do, but there may be opportunities, particularly if you're in a situation where you have some negotiation leverage or you're entering into a new license agreement. Thirdly, again, when you're structuring a new license agreement, you can consider using a bankruptcy remote vehicle. And you can also consider incorporating contractual step-in rights to make sure that you can pay to maintain the IP, to make sure that the licensor and the insolvency practitioner doesn't simply allow it to lapse. It's always a good idea to make sure that you limit the rights of your counterparty insofar as possible to assign their rights under the license agreement. And then for sublicenses, we've heard that in Germany, for example, sublicensees are particularly privileged and well protected. But in the other countries, it's definitely a good idea to consider including, again, a contractual right in a sublicense for the licensee to take a direct license from the head licensor in the case of a head licensee insolvency. And of course, make sure you continue to pay royalties as they fall due to prevent any other breaches of the license agreement, which might give the insolvency practitioner a further grounds for termination. There are a couple of other recommendations, jurisdiction specific, which I'll ask Jamie and Dirk to run through quickly as well, US and Germany. So Jamie, do you want to go first?
Sure, and I've switched over to headphones, so hopefully you can all hear me. The main thing I wanted to mention on jurisdiction, US specific, pay attention to and respond to notices from the bankruptcy proceeding. Failing to do that, you're putting your license at risk of the fate of it being decided by the bankruptcy court, which will go ahead and do things that affect rights and obligations of parties absent appropriate objections being made or elections to preserve rights being made. And then the other matter for licensees where access to some ongoing support or technical embodiments are important, that wouldn't be a patent license, a pure patent license, or a trademark license. But you'd mitigate the risk of a licensor bankruptcy in that the licensor gets out of all those affirmative obligations to provide support and maintenance, for example, through an escrow, and seeking license rights that aren't triggered off of the licensor's bankruptcy filings, which would be void as ipso facto clauses, but off of events that are independent of a bankruptcy.
Yes, and just two very brief thoughts for Germany. German law is extremely critical of termination rights that apply in the case of an insolvency. Generally, any contractual obligation that would prevent or circumvene the insolvency administrator's right to choose either to continue or abandon the contract would be void. So what can be done is providing security rights over the license IP, although that is often, of course, a bitter pill for the parties to swallow, as it would affect the ongoing value of the rights if they were to be disposed of to a third party later. And if any termination rights are provided for, then they should be worded in a way that they do not actually refer to an insolvency event, but rather to more general concerns that would create conditions that are usually met if a party becomes insolvent, but does not actually tie it to the insolvency. Finally, as I've said, and has been mentioned before, the privilege that sub-licensees can enjoy it does create an opportunity to license rights via an IP holding entity, so that the sub-license structure, for example, within a group of company, would not be affected in the case of an insolvency of the principal licensor. And with that, I think it's back to Adrian.
Thanks, Dirk. Wonderful. Okay, so we will now move on to our cross-border case study, which is exactly the same facts as the ones that you have now become a little bit familiar with, but with one difference. And here we're just going to focus in particular, the patent license between Mobilitex and its licensee Connetics. And the fact change that we're going to tweet here is that Mobilitex is based in Germany and Connetics is based in the US. So previously they were both in the same jurisdictions. Now we're changing the fact pattern. And that hopefully is straightforwardly illustrated on this diagram here, where again, you can see it's now Connetics, it's in the USA, Mobilitex is in Germany. In fact, we've chosen other countries as well for Ultrasoft under the trademark license and for Glam Touch under the trademark sublicense. But in the time that we've got, I think the same issues actually largely apply. So we'll just focus in on the key issue that arises. And Marie is now just going to give us a couple of pointers. As we said at the beginning, the already complex analysis that we've been running through on a domestic basis becomes considerably more complicated once you introduce cross-border elements. So we'll give a couple of pointers here, but it won't be an exhaustive analysis. So Marie, over to you. Hello, do we have Marie?
I forgot to unmute. Sorry for that. Yeah, as Adrian was saying, I'm not going to go through a full analysis of the case. I'm just going to point out some issues that can arise in a cross-border insolvency situation. At first, I wanted to mention some rules, principles that apply in the situation. So first, it's the UN Central Model Law on cross-border insolvency that has been adopted because of the problems that arose in the framework of cross-border insolvency, which are more and more frequent nowadays. And this set of rules is really designed to help recognition of acts that will be taken by insolvency administrators in one country, in other country where there could be assets of the debtors or creditors of the debtors, and also cooperation between the states where the cross-border insolvency happens. So in principle, the insolvency proceedings pending in the debtor's center of main interests. So this will often be the registered office, but it could also be someplace else where the main interest would be identified, will be generally be the principal jurisdiction. So this is where most of the decisions in relation to the managing of the insolvency of the debtor will take place. However, laws of other states where assets or creditors are located may interplay, and the insolvency administrator may have to face the applications of provisions of foreign law that he would not have expected. We will see this in more details just after this with an illustration of a case. But I first want to mention that at the EU level, there is also a cross-border insolvency regulation, which governs the rules of jurisdictions for opening of insolvencies and the law applicable to the different aspects of the insolvency process. I won't go into any details in relation to this regulation or even the model law, because not being an insolvency specialist, I wouldn't be able to accurately inform you on this point. And so I'm going to move to the decision that we wanted to talk about with you, which in place of trying to resolve the case that we have given, we wanted to talk about this decision, which has a very similar setting. So it is a decision. So Qimonda, which was a German manufacturer of semiconductors, which filed for insolvency in Germany in January 2009. Sorry, and this manufacturer had a lot of patents, 10,000 patents and 4,000 US patents. And at the time of the filing of the bankruptcy, of the insolvency, the patents were subject to numerous cross-license agreements with competitors. So the center of main interest of Qimonda were in Germany, and so the insolvency proceedings, the main insolvency proceedings, were filed in Germany and Munich, and the German insolvency proceedings started to deal with all the assets, and given the wide number of assets that were located in and of creditors that were in the US, the German insolvency practitioner filed a petition to obtain recognition of the German insolvency proceeding in the US, and also requested to be granted the right to administer the assets in the US. Both requests were granted, but the power given to the German insolvency practitioner to administer the assets in the US was subject to US provisions. And as we will see, their conflicts has arisen between the German insolvency provisions and the US insolvency provisions. So what happened is that the German insolvency practitioner had a look at the license agreements and came to the conclusion that the license agreement did not provide useful compensation to the estates, and as a result had to be terminated pursuant to Section 103 of the German Insolvency Code. Based on this assumption, he started sending out termination notices to the licensees in the US. Of course, the licensees weren't really happy and reacted to this notification, referring to, amongst others, Section 365 N of the US Bankruptcy Code, which was already mentioned by Jamie in the beginning of the presentation, which limits the trustee's ability to unilaterally reject license to debtors of intellectual property rights. So they were saying to the German insolvency practitioner that he was not allowed to terminate the license, as he just did. So what the German insolvency practitioner did was to file a motion for determination of inapplicability to Qimonda of Section 365N. And in the end, the US Bankruptcy Court ruled in favor of its application. So this really shows that what we saw before in the domestic law could be quite straightforward in a domestic situation. But once we go into cross-border insolvency situations, there is even less certainty than in domestic situation, because domestic administrators could be facing the application of other rules, which could be totally conflicting and in contradiction with the provisions. So this is what I wanted to say about the decision. And now we can go to the next situation, which is the insolvency of the licensee.
Great.
Right. Yeah.
Thank you, Marie. That was actually a really interesting case there, where German law, non-exclusive patent license, said it could be terminated. It also said center of main interest Germany, so German law should apply to the global assets. But the US-based licensees managed in relation to the US territory to have US law apply, and Section 365N saved their licenses. So now we'll move on and look at insolvent licensees. We're going to turn everything on the head that we've been looking at so far. The licensor remains solvent and the licensee becomes insolvent. We have, just looking at the time, we've got about 10 minutes between us to talk about this, and then we'll have 5 minutes at the end to talk about the Q&A that have been coming in. So what we have done here is, again, tweak the case study. And as you'll see here, so in this case, Mobilitex managed to remain solvent despite the impact of the pandemic. But in this case, it's Ultrasoft that found itself in difficulties and entered into an insolvency process. So here it's the licensee under the trademark license, which has gone into an insolvency process. So looking at this just briefly from a UK approach, a first point to note is that IP licenses don't automatically terminate under English law on the licensee's insolvency. However, most IP licenses which are competently drafted will include, certainly at least historically included, express terms allowing termination on licensee insolvency. And the courts have upheld those to date. They've said that those are effective and that they're not in violation of any principles of bankruptcy law. However, please note that within the last couple of weeks, English law has now changed, and we've got a new act, the Corporate Insolvency and Governance Act, which applies to any UK insolvency process, regardless of the law governing the license agreement, and regardless of the, I guess, the centre of main interest or the domicile of the licensee. Of the licensor. So you could have a situation, as long as the licensee is in the UK and subject to an English insolvency, then this act will kick in, and that essentially prohibits termination of contracts, including IP licenses, where termination arises simply from the mere fact of entering the insolvency process. Rights of termination which arise prior to the insolvency process can be exercised, but only up to the time that the insolvency process formally starts. You might have a very short window. So if you've got a license where there's some existing termination rights, then you might want to consider exercising those very promptly, because you won't be able to do that once the licensee enters insolvency. Moving on briefly to talk about sub-licenses, they will typically terminate on termination of the main license. We don't have in English law the approach that Dirk has explained in Germany of privileging and protecting sub-licensees. There's no rule of law hard and fast to this effect. The courts will determine each case as a question of construction of both the sub-license and the head license. And there have been one or two cases where on the correct interpretation of the agreements, it was found the sub-license continued, but there's no hard and fast rule to that effect. And then the insolvency practitioner, of course, can only sell the benefit of the license if the license actually on the face of it allows that. So many license agreements prohibit assignment, and in that case, they can't be assigned. The insolvency practitioner doesn't in England have any powers to go beyond the terms of the license and ignore them in order to realize value for the bankrupt estate. With that, I'll ask Jamie to make a couple of comments about any US issues.
Sure. So the situation, I'll just touch on this briefly, is broadly consistent with Adrian's description of the analysis in the UK, at least under the new law. That is, you cannot a clause in a contract that says that this license terminates upon a licensee's bankruptcy would be void as an ipso facto clause. Whether the licensee's rights terminate or not is highly dependent on where the bankruptcy proceeding is, where the case is filed in the US. And that's because for the license rights to continue, the licensee or the debtor in possession has to assume the agreement. And there's a split in the US courts as to whether an inbound license would be assumable. Some courts take the view that the new entity in the bankruptcy is a different entity than the one before the bankruptcy. And so the contract or license is assumable only if, under applicable non-bankruptcy law principles, that contract would be assignable. And for that analysis, you don't look at anti-assignment clauses, you look at whether a non-exclusive patent license in the absence of an anti-assignment clause is assignable as a matter of law. And some courts view the post-petition entity as the same entity, meaning it's assumable. So the big takeaway from a U.S. law perspective is just to understand that there's different rules about assumability of an inbound license agreement depending on which jurisdiction you're in the U.S.
Great, thank you, Jamie. Dirk, have you got any comments about the position in Germany under a with a solvent license or insolvent licensee?
I do. Then we're just going to skip Germany, and Marie can then pick up afterwards. I'll be very brief. I'm conscious of time. The situation basically is similar to what we've just heard. A license will not automatically terminate. Again, it's up to the insolvency administrator to choose whether the license should continue or not. And in the interest of having legal clarity, the other party can force the administrator to make this choice at any time. So what are the options for protecting against the administrator's rights to continue the license with a licensee that is otherwise insolvent? Well, first of all, do provide for termination rights that you can exercise prior to the insolvency event. So if there's an option to get out of the agreement before the actual insolvency application is made, then that should be used. As I said before, provide for termination rights that do not refer to the insolvency situation expressly, but whose conditions would generally be met in such a situation. An example from a Supreme Court case would be a termination right in the very abstract, under the very abstract condition that a party cannot be expected to stand by the agreement. And that is certainly the case if the party is insolvent without actually referring to the insolvency. Final point on the termination rights, it's important when drafting the license agreement to provide for certain obligations of the licensee that a licensee will generally not be able to perform if it is insolvent. An obligation to actually exercise the license, or certain KPIs, minimum sales figures, similar things, that could be included in an agreement, and that a termination on that basis for failing to meet those obligations would certainly be upheld in the case of an insolvency. Finally, whether the insolvency administrator can assign the rights will depend on the language of the agreement. So that's also something that should be considered when drafting the agreement. And the last point, once an agreement has been terminated, any outstanding royalty claims of the licensor go to the back of the queue and have little chance of actually being realized. And with that, I hand back to Marie.
Actually, because of time, Dirk, I think what we'll do is we'll go straight on to the recommendations at this point, and then deal with questions, and then wrap up. So in terms of key recommendations for licensors, in this case, faced with an insolvent licensee, here are our collective thoughts. Obviously, as Dirk has just said, include termination rights, which kick in not just on a formal insolvency, but also cover certain pre-insolvency events. Limit the assignment of the license or the assignability of the license by the licensee. So make sure that, as we've talked about in some jurisdictions like Germany and the UK, whether an insolvency practitioner can actually, at the end of the day, realize some value by selling the license depends on the terms of the license agreement. Think about drafting it as a conditional license, where the license is subject to the payment of all the fees. Fourth bullet here is to remember the impact on sub-licenses and to try and draft, bearing in mind what happens if there is a sub-license. Should it automatically terminate, or should it become a direct license between the head licensor and the sub-licensee? And then, of course, another point, a commercial point, is consider structuring remuneration fees so that the fees are front-loaded, so basically upfront, so that your exposure, as in with any creditor, is limited to your licensee. I think there was one other recommendation, a couple of other recommendations for the US, Jamie, which you could speak to, perhaps.
Yeah, these are really, we've spoken to these already, but again, not triggering termination rights off the actual bankruptcy filing, similar to Dirk's point about triggering off of non-bankruptcy events that would likely happen in the event of a bankruptcy filing, but aren't tied to the bankruptcy filing. And then again, if you're a licensee dependent on inbound licenses and entering bankruptcy in the U.S., the jurisdiction of the bankruptcy filing is important. With that, I think we've reached the Q&A.
The IT gremlins continue, but I think I am back with us, back with you. Can you hear me?
Yes.
Yeah, great. We've had a really interesting question raised by one of the delegates around the impact on all this analysis that we've been talking about of what happens if the underlying IP right is subject to legal challenge. So presumably if there's a pending invalidity action or revocation action against the right. I mean, one point that occurs to me is that there is often a moratorium on court actions once you enter bankruptcy or administration. So it could be the case that those proceedings are actually compulsorily stayed. But I don't know if anyone else, if any of the other panelists have got any views as to what the impact would be. Just chip in, Dirk or Marie or Jamie. What are your views?
Well, in Belgium, in the event of bankruptcy, the procedures would not be stayed. They would go on, and so it would still be at the discretion of the administrator, who will have to decide on either to take over the proceedings or to let them, or just to settle the proceedings. He can decide not to take over proceedings, but with all the risk that it entails. The only situation where there is an impact on proceedings is in the context of judicial reorganization, where there's no enforcement that can be done, but it wouldn't have an impact on the IP itself, on IP rights being challenged. Yeah, that's for Belgium. So it would depend on the choice of the administrator.
Thanks, Marie. And JB, I think we were chatting offline, and you were saying you didn't think it would have, that there wouldn't be much interplay between the two analyses.
Yeah, it might be a question that requires some nuance and thought, but nothing occurs to me as to how that would affect the analysis under U.S. bankruptcy law principles.
Okay. And Dirk, any final thoughts from you?
Yes. Well, it will certainly influence the decision of the administrator to choose continuation or abandonment of agreements, because if the IP right that is licensed out is subject to challenge, then the insolvency situation may be a convenient way for the administrator to get out of the contractual obligations that exist under the agreement and that he may not be able to fulfill anymore. So I think it will have an impact, maybe not legally in the sense that it directly changes the legal implications, but it will certainly play into the decision by the administrator about what to do with the license that he has got on his hands.
Thank you, Dirk. Well, with that, we've come up against time. I think wrapping up, it only remains really to thank the panelists, to thank Dirk, Marie, Jamie for joining me, of course, to thank the delegates for taking the time to dial in and be with us this afternoon. I think it's fair to say that the analysis, even on a domestic basis, is relatively complicated. There are some important differences between the jurisdictions, clearly, even though there's quite a lot of commonality. And in some cases, obviously terminology changes, but the actual end result is not that different. But I think it would be fair to say that there is some complexity here, and clearly if you're facing this situation for real, then do take advice. I think detailed advice, because things can play out in these high-stakes situations in quite different ways. With that, I think we'll just thank you again for joining us and say that we'll circulate the slides afterwards by email, and there will also be a recording available of the webinar if you'd like to go back and re-listen to any parts. Thank you for joining us. Thank you.